Good afternoon. We're going to go ahead and get started with our hearings. Colleagues, we have, I think, 8 bills. So the first bill we have is Delegate Ziegler, House Bill 148. Please, if you have a panel, you can bring them up as well.
Don't touch the buttons, the microphone buttons. Oh, we need another chair. Let's see. Could I, yeah, could I bring it up after? Thank you very much. Good afternoon, Chair Wilson, Vice Chair Crosby. He's not here. Members of the committee. I am here with House Bill 148. For the record, Delegate Natalie Ziegler. This is a very simple consumer protection bill which aims to prohibit automobile insurers from increasing premiums after you have a not-at-fault accident. So what it does, well, this issue was brought to my attention by a constituent who was rear-ended by a tractor trailer, and he's here today to tell his story. But very simply, I just added to our current existing law, which prohibits insurance companies from canceling or refusing to renew a policy if you have 2 or fewer not-at-fault accidents in 3 years. So it's a little complicated, but all it does is say, and also you can't increase the premium. Because if you double somebody's premium, it's effectively the same thing from an affordability standpoint as canceling or not renewing. And I think we all feel like if you pay your premium on time for years and years, and then you're stopped at a red light and you get rear-ended, that's something that the insurance company should deal with. Presumably they're collecting from the other guy's insurance company. So that's really all the bill does. Our neighbors in Virginia and the District of Columbia also have laws prohibiting increasing premiums after a not-at-fault accident, along with 14 other states. So I think it's a reasonable and flexible bill in the sense that if there is somebody who is, I don't know, a chaos magnet and they have 7 not-at-fault accidents, the insurance company would be able to raise their rates. But for somebody who just has a bad thing happen to them once in a blue moon, I don't think it's fair. So I respectfully ask for a favorable report on Bill 148. Thank you.
Thank you, ma'am. A brief question. Do you have, is there a limited amount of time? Because, you know, most of everyone's policies renew every 6 months. So I don't know how, if somebody can tell me on your panel how other states handle it as far as what is that, you know, does this actually freeze your rates? Because I think everybody's experiencing this right now. Every 6 months, your rate's going up anyway. And I would ask somebody to, you know, elucidate that that issue as far as how long does this freeze your rates for?
I'm going to turn to somebody who knows more about this than I do. Thank you. Does somebody want to answer that? What? The question about.
If somebody knows, that's great, but go ahead and just keep testing. That's fine.
I mean, so if I understand you, what you're saying is your rates are going to go up anyway. How do you know whether it's because you had a not-at-fault accident or they just raised your rates anyway? Yeah.
The goal is to basically freeze your rates in place.
Right.
You know, in 5 months or 1 month when you're set to renew, are they still frozen or do they go up, you know, additional percentage like everyone else? I just want to know how we figure it out to make sure we're protected. That's fine. You can go ahead and start your testimony, sir, or whoever wants to go next.
Okay. Who wants to start? Do you want to start?
Sure, I can start.
Yeah, why don't we have Carl start?
Good afternoon. My name is Colt Romberger. Thank you for giving me the opportunity to testify before you today regarding my personal experience as a Maryland resident with a auto insurance premium increase. On August 3rd, 2023, as I was driving back with my horse and a passenger from a veterans event held in Texas, my vehicle was rear-ended by a tractor trailer in Illinois. My horse was injured, as well as both my passenger and I. My horse trailer and my truck were completely totaled in the accident. A few weeks after the accident, my wife and I received a letter from our insurance carrier. Both of our jaws dropped when we saw that the increase more than doubled our insurance premium. Our insurance premium at the time was $643.59 over a 6 months period to $1,337.12 over the same interval. If you do the math, that's a 107.76% increase. I don't know about anybody else in this room, but as a family with a child that had just turned 1 year old, an increase like that is a financial gut punch. The justification for the increase was stated as a tier change due to the aforementioned accident on August 3rd and explicitly stated rear end not at fault. To add insult to injury, they provided my wife and I a document titled Offer to Exclude. The offer to exclude includes a statement in part, we the insurer will agree not to charge you the increase in premium if the named insured agree to exclude coverage under the policy for the individuals whose driving record or claims experience justify the increase in premium. The named driver was me, a former police officer, a military veteran with over 16 years of service at the time, with an impeccable driving record by any modern standard. For a not-at-fault accident I had no control over. Again, my truck was rear-ended by a tractor trailer. In closing, I want to thank Delegate Ziegler for hearing the issues that are affecting her constituents, and more importantly, for taking action to correct those issues. Plainly put, it's wrong for an insurance carrier to increase the premium for a driver when the justification for the increase is a not-at-fault accident. Again, thank you for your time.
Sir.
Yeah, whoever's next.
Well, you can go ahead.
Okay. Thank you. I'm Michael DeLong, a research and advocacy associate with the Consumer Federation of America. We're an association of over 200 consumer organizations. We work to promote consumer interests. We urge you to support HB 148, which bans auto insurance companies from increasing consumers' premiums after not-at-fault accidents. This bill, it's going to provide much-needed premium relief to safe Maryland drivers who are currently being subjected to unfair premium hikes. Auto insurance premiums have increased dramatically in recent years, well above the rate of inflation. Maryland drivers are struggling to pay their premiums or even driving without insurance, which puts themselves at grave risks and increases costs for all drivers. This bill, it targets an especially unfair practice, and if passed, it will help reduce auto insurance costs for many safe Maryland drivers. It bans auto insurance companies from increasing premiums on the basis of crashes caused by other drivers. Our research has found that safe drivers who are in not-at-fault accidents often see significant auto insurance rate hikes. One of our past studies found that Allstate, Farmers, Geico, and Progressive all imposed substantial premium hikes on drivers after they were in not-at-fault accidents. And these premium hikes ranged from 5 to 17%. We list more information in our written testimony. And our research also found that on average, Baltimore drivers experienced a $258 premium hike after they were in not-at-fault accidents. As you've heard, in Maryland, a driver who is rear-ended while lawfully stopped at a red light can then face a big premium hike from their insurer in the wake of that crash. This should not be allowed. And penalizing safe drivers who are hit by other cars, it also discourages drivers from filing legitimate claims. If they see their premium go up after an accident where they're not responsible, they're less likely to file a claim and get the money they deserve. 15 states already protect consumers by prohibiting these premium increases after not-at-fault accidents, including Virginia, and legislators should protect Maryland drivers from premium hikes after accidents where they've done nothing wrong. We thank Delegate Ziegler for her work, urge the committee to support this bill. Thank you.
Okay. Good afternoon, Chair, members of the committee. For the record, my name is Marceline White, Executive Director of Economic Action Maryland Fund. Economic Action is a statewide organization that focuses on economic rights, equity, and housing justice through research, education, direct service, and organizing. Our direct service programs touch every county in this state, and our 12,000 supporters work to support an economic rights agenda. We're here in strong support of HB 148. You were all in the briefing this this morning, you heard about the skyrocketing cost of car insurance with another increase along the way. This is a simple, common sense bill that is about fundamental fairness. It will save Maryland drivers who are not at fault from rising auto insurance costs. You've heard what the bill does. You know, Maryland is not an at-fault state. Generally, the insurance company of the at-fault driver pays the damages caused by a crash. So there's no reason why a loss by the insurer, why the insurance company suffers a loss for the not at-fault driver. Our neighbors in Virginia and DC have these policies. Their markets remain competitive. You may hear that the sky is falling if we pass this, but in fact, our neighbors around us have these exact same policies and have competitive markets. We simply believe that drivers should not pay more for accidents where they are not at fault, and for these reasons, we urge a favorable report. Thank you.
Good afternoon, Chair Wilson and members of the committee. My name is Neil Dubofsky, and I'm here today to testify on behalf of the Maryland Association for Justice, a organization of plaintiffs' lawyers dedicated solely for the purpose of ensuring securing justice for injured Marylanders. MAJ is strongly in support of HB 148 for the following reasons. The current version of the statute already reflects the legislature's intent to ensure that consumers are not punished for making claims related to accidents for which they were not at fault. This amendment is a natural and important extension of that principle that will ensure that Marylanders are protected from increased insurance premiums in that scenario. When a person makes a no-fault claim under their own policy, they are attempting to avail themselves of coverage for which they have already paid premiums. To permit insurance companies to increase premiums as a result of those claims would have two adverse effects. The first, it would enable insurance companies effectively to double dip by charging consumers on both the front and back end of accidents for which they were not at fault. The second is that it would operate to dissuade consumers from utilizing coverages under their policy for which they have already paid premiums for fear that future premiums would increase. And I would mention here parenthetically, as somebody who is a plaintiff's personal injury attorney, this is something I see frequently in my own practice. People injured in accidents where the other person either was uninsured or in a phantom vehicle situation where now they have to avail themselves of coverage under their own policies. And they say to me, I don't want to go under my own policy because my premiums are going to go up. And so the effect in some situations, and I've seen this very directly, is that they choose not to pursue a claim for that fear. This amendment takes that off the table. It allows people to obtain justice when they're injured in accidents that were not their fault. So again, MAJ supports this amendment and thanks Delegate Ziegler for proposing it.
One question, Pippi?
Thank you, Mr. Chair. Thank you, Delegate. Good to see you. I just had a question, and part of it came from one of the testimony, and it was that they were concerned that as the bill is written, it would be hard to distinguish between is the increase in premium or cancellation or any of that related solely to the not at fault accidents, or could this be construed to where it would prohibit any increase if there was a mixture of at fault accidents and not at fault accidents? And I was kind of reading, the bill's very short. It's very, very short, but I'm just wondering why you didn't use the word like solely. Like if a insured, you know, their rates couldn't go up if there was two not at faults solely based on the two accidents in which they were not at fault. Like there's no language that really clarifies that, and I didn't know if you could respond to that.
Yeah, I think that's very similar to the chair's question. And right, obviously, we're not trying to freeze insurance rates, although that would be nice too, but no, we can't do that. I mean, I think that's a good question. I wouldn't be necessarily averse to the idea of adding the word solely. And I think Well, let me see what some of our insurance experts have to say about that. But I do take your point that it is hard to tell, when your rates go up, your rates just go up, and you really don't know what the deal is. And I think we all assume, well, cars are more expensive and, labor is more expensive, and that's the reason. But it is a little difficult to tease that apart. So let me see if somebody else has a better answer. Okay. Yeah.
Okay. Just real quickly.
No.
Okay.
No.
To the gentleman with the cowboy hat on. Yes, sir. I know you mentioned some of this. Did you provide written testimony, or is that all oral?
I just provided oral testimony, sir.
Okay, so a couple of quick follow-up questions. I know you mentioned some of this. When did your accident take place?
It took place on August.
Yeah, thank you.
On August 3rd. Yes, on August 3rd. I'm sorry.
Of 2024?
2023.
2023. And where was it?
It was in the state of Illinois.
Okay. All right. And who was the insurance provider?
I would rather not say that currently because I am in some litigation, if that's possible.
Yeah, that's okay. You can tell me later.
Yes, sir.
And the last follow-up, did you or anybody on your policy have had any accidents in the 3 years prior to that accident? Any at fault or not at fault, or any accidents at all that were filed?
I'm trying to think right now, not off the top of my head, sir.
All right, thank you.
Not that I recall.
Thank you, Mr. Chairman. Just to follow up to the chairman and Delegate Pippi's question, you said this was being done in other states and you used Virginia. Did you adopt language from Virginia, or is this new language? Because if they're already doing it, it would seem obvious we would just adopt their language.
I didn't because I wanted to follow Maryland's law, so I just added that phrase, or increase the premium, to our existing law, which already prohibits canceling or not renewing. It seemed to me that that was the intention of the Maryland legislature. This is sort of a loophole, if you will, and so that's why I kept it consistent.
So do you know how the other states address the issue of attributing the rate increase solely to the non-at-fault accident? Do you know how they were able to address that?
I don't, but maybe somebody on the panel does.
We can get that code for you, first of all. I'm happy to pull those for you. Secondly, I'd say, as the gentleman who told a story shared, he got a notice from the insurance company that the rate increase was due to his accident. So I think that isolates it in and of itself. There's obviously going to be other factors that increase your insurance rate. So I think in implementation, what this would do is just say you couldn't increase in that way and you wouldn't get that kind of notification.
I mean,
But I'm happy to find the code for the
he was
others.
fortunate that it said that. I doubt in the future they'll state it's attributable solely to that.
Right, I agree. And the other states' laws that I've read are actually less specific than Maryland, and usually just say that you can't raise somebody's rates after a not-at-fault accident. And they really, I haven't seen anywhere where somebody addressed how do you tell the difference, which is, of course, an excellent question.
Okay. All right, thank you.
Thank you. What we have been hearing, good afternoon, by the way, everyone. We've been hearing a lot here in this committee. We've had several briefings from various insurance entities, the MIA, some of you were here earlier, and we're hearing a lot from our constituents, obviously, about the rates constantly going up. And while this is an attempt to help the individual consumer who's not been at fault, how would you address the issue of the overall problems that we're hearing, or the causes, I'm sorry, that we're hearing about the increased insurance rates? premiums. So, for example, one of the things that we keep hearing about is the cost of repairs. The cars are much more expensive. It's harder to get the parts. And some of that is attributing to the costs of the rate increases. For an individual who was not at fault, that like in this gentleman's case, suppose that individual who hit them, the cause of the accident was uninsured, which was mentioned, those costs still have to be spread amongst all of the ratepayers, right? Because the insurance company still has to pay out, which means that the cost is still consistently increasing, and that individual, whether they were at fault or not, just simply because of the issue with rate increases, the insurance rates are still going to go up, and it's going to be spread amongst everyone. While that individual may not, in his, and let's just say it, and I'm sorry, sir, I don't remember your name, but the individual who testified here, his rate may not increase simply because of that particular issue, but over time it's going to increase anyway because it has to be spread amongst everyone. So how would you address that? What would you say to that?
So I actually have an answer to that, Delegate. Anytime somebody's availing themselves of that provision of their policy when they're injured by uninsured people, what they're doing is they're taking advantage, or they're using what's specifically referred to as uninsured motorist coverage under their policy. So if you back up from before the accident happened, the insurance company has given them a provision under their policy for which they have been paying premiums, specifically for the purpose of an uninsured driver causing an accident. It is already built into the insurance metric, and they should have factored that in, or should be factoring that in determining what they're charging for premiums for that specific coverage. It is inherently unfair to then penalize the person once they use the coverage they've already been paying for that exists solely for that purpose, to then say, okay, you were in an accident with an uninsured motorist, that wasn't your fault, you've been paying us for uninsured coverage, and now on the back end, we're going to then increase the premium over what it was. Again, as I said, it's double dipping, that the coverage exists for that purpose.
I understand what you're saying. I'm talking about the masses, though, because it's going to be spread across, and maybe that's a question that can be answered by, because I know that we have some people from the industry who are going to come up and speak, and maybe they'll be able to answer that. But the bottom line is that while he may not be charged, it's still going to be spread amongst the masses eventually, I guess is the point that I'm getting to, because it's basically just the law of large numbers, right? So, we wouldn't expect that for that reason that the individual rate premium should increase, but it's going to ultimately increase for everyone.
I think I understand that certainly what your question is, and I think I would say in response to that, that already has been built into this model when you have uninsured coverage. There are constantly accidents happening, being up to this point, even before this amendment is adopted, that involve situations where uninsured motorists are causing accidents. And what this says, this amendment says, is that the individual, that cost is already being apportioned among the masses, to use your phrase. What this bill is designed to do is to simply say that this specific individual doesn't get to be punished with a specific premium increase solely for them as a result of a not-at-fault accident.
Can I add something? No, that's okay. Go ahead, sir. Yeah.
Okay.
It kind of answers a bunch of questions that have been asked. So just to specify, and this is just for my case here, even though it was 107% increase for my wife and I, the insurance company identified it as an 89.64% increase because they had already built in a increase that was going across the board, whether you were in an accident or not. So to your point, ma'am, and I think some of the other points is the individual or the policyholder is still going to be subjected to a rate increase, just like every other Marylander is going to be subject to that rate increase. This bill just protects that we don't have to increase an additional 100 or 89% above.
Thank you.
That concludes this panel. You guys very much. We have,
Thank you.
Frank Schneiderman, and, Michael DeLong.
Michael DeLong was here. We already.
That was me.
The last, paperwork is Frank.
Sorry.
Go ahead, sir.
Thank you. Thank you, Chair Wilson, members of the committee, for the opportunity to address this bill. I'm Franz Schneiderman with Consumer Auto Maryland, and I just want to add my voice to those of other advocates suggesting that this policy of charging people more as a result of accidents that weren't their fault is unfair and burdensome. I'll try not to repeat what others have said, but you know, the cost of insurance has gotten very, very high. Bankrate recently put it at about $2,800 a year on average for Maryland consumers, and many people pay much, much more if they have, you know, troubled credit histories, or they live in Baltimore or have other high risk factors. And this, you know, fundamentally, it just seems not fair to punish people for accidents that weren't their fault, especially when we're not a no-fault insurance state in the first place, and so the insurance company in question isn't paying for those damages in the first place. And you know, I think it works to punish people for using their insurance at all, because then if you file any claim at all, your rates can go up, and people are paying, in many cases, $3,500, $4,000 a year for insurance, and, you know, they get punished for using it at all. And I want to say also that, like other factors, I think this burdens lower income drivers more than other drivers. The reason for that is both of the CFA study from 2017 that Michael DeLong mentioned suggests that middle income drivers on average face higher price increases after not at fault accidents than their higher income peers. But also, I mean, quite frankly, lower income drivers can't afford to absorb the cost of an accident. Higher income drivers, you know, if you have a $1,500 in damages, you can pay that out of pocket and avoid having your insurance going up. Lower income drivers probably aren't in a position to do that. So I think that it's an unfair and burdensome rule that we allow these price hikes, and I hope you'll agree to change the practice. Thank you.
Thank you very much. Any unfavorable, any other questions? No, we have the unfavorable, Bryson Popham, Nancy Egan, Bob Hinton, and Marty Lawson.
You want to go first? You want me to?
Sorry, I didn't realize I still had my name tag on, so now you know who I am. I'm sorry. My name is Nancy Egan. I represent the American Property Casualty Insurance Association. My members write 64% of the private passenger auto here in the state of Maryland. I just want to address two things that was asked in the previous panel. Look-back periods in Maryland are limited to a 3-year period. And when there is a rate increase greater than 15%, an insurance company must send out a notice specifying the reasons that they are raising your premiums more than 15%. It has to be detailed. This is when it's not just a general rate increase. And in that, they also offer the right to exclude a driver. And I know that's upsetting to people when they receive it, but it's something that's mandated under the law. As you've already heard, this bill would limit a company from underwriting their risks for any losses of less than 2. What has not been mentioned is that this does not apply, this doesn't limit itself for not-at-fault accidents, but it also applies for comprehensive losses. So this would limit a company to look back at someone that may have had a stolen car, a tree fall on their car, they hit a deer. Those are all losses that come out of the pocket of the insurance company that they're paying. Many of our insureds in the state offer loss-free discounts, and they also have different ways of looking at their risks. So that person to your left may be with a company that doesn't have loss-free credit, while the person to the right may be with a company that does that. When you limit these exposures, what Delegate Harris has already mentioned is that you're going to take the ability for an insurance company to underwrite. So those losses that we specified and added on to a premium of one person then would be spread across the premiums of all of you, because you're limiting our ability to underwrite the risk. And I'll take any questions. Thank you.
Nancy, I guess I have a question. I'm somewhat flummoxed here on your explanation of, yeah, pretty much everything you were just talking about. We pay insurance. It's like you're almost saying that, well, you use it, it's a problem, then why would we pay it? And in addition to having insurance, I have insurance in case somebody hits me that's not insured, and I pay extra. I just got my new $6,000 every 6 months is what I pay in insurance. So
Wow.
I would be so offended, this logic, because I just got it. It went up from, remember last year I was saying it was $4,400? Yeah, now it's $6,000. This is on people that are over 50. Car insurance. We're already talking about all these ridiculous rates, but then to know that our rates are meaningless, what we pay becomes meaningless, because if somebody hits me and you look back and say, yeah, and a tree also fell on your car, which is why I have insurance.
And I understand
the logic
that.
of how dare you use your insurance that you're paying a grip for. This is not like I've got, apparently I've got very expensive insurance. I am patently offended that somehow, because in good faith, I paid on time, I dealt with the increases, and somebody wrongs me, and because I know how that goes, because I'm also a plaintiff's attorney, and I know who you're suing. For everything that you lost, you're going to sue that person. You're going to sue their insurance. Now, if they're uninsured, I get it. I just don't understand how we can sit here and discuss somehow that I shouldn't use my insurance. You know, that's a risk of me using my insurance. So please, if you could explain that, I would love to hear it.
Well, I think we hear time and time again that people would like their insurance to reflect them specifically and not as the population as a whole. So insurance companies differentiate between different drivers to try and give the safest drivers the best rates. If you pass the bill, then the ability to look at number of comprehensive losses, not at fault accidents, in their review of tiering or underwriting a risk or et cetera, then those losses are going to be spread over everyone, because now you're taking away some people that were getting a safe driver credit. You're not going to be able to do that anymore.
But
So
ma'am, by your argument,
go ahead.
he was a safe driver. So that's why I guess I don't understand that logic. He got hit. So he's a safe driver. Or maybe I should ask this a different way. Am I not a safe driver because I get hit? Is that my fault? Am I putting myself in a bad position because somebody ran a red light or a drunk driver hit me? Does that make me an unsafe driver?
Each company has their appetite, and all I can say is, Delegate, that we've always said that each company has different underwriting guidelines, and the best thing is what that company does versus the company down the street could be different.
No, I know that, but you in defending your statement said, well, you know, if my rates don't go up, then the safe drivers are going to carry that burden.
And I should say.
And I would say that me getting hit still makes me a safe driver.
Yeah, and I understand that, but.
You're saying that may not be how every insurance company looks at it, which now I'm doubly offended because I just don't understand what I'm missing here.
And I understand your concern, and some companies call it a loss-free credit. I can't be more specific than that.
But you understand, look, I know you have a job to do. I apologize, but you know, what you said was concerning. The logic is very concerning that somehow a safe driver can become an unsafe driver because there was an unsafe driver around, or a tree falls on my property. And again, I would understand all this if insurance were cheap. I got it. If this was, but it's extraordinarily expensive and going up. And well, maybe I'll hear some clarification from the other witnesses, please.
Problem about going first.
Good afternoon, Mr. Chairman, members of the committee. Bryson Pop. I'm appearing today on behalf of 3 clients, the Maryland Association of Mutual Insurance Companies, which is a trade association of insurers doing business in Maryland, Agency Insurance Company, which is a company founded here and operating here in 1989, and also the Insurance Agents and Brokers, all in opposition to House Bill 148. We need to start with some really baseline information here, starting with this is not a new issue. Delegate Harrison, you had it exactly right. That's the one point that I would urge every committee member to remember here. If you pass this bill, some people are going to benefit, everybody else is going to pay. They may not pay a lot, but they're going to pay more. So the question is, what's fair? We have an insurance law in Maryland that's been around probably for 100 years, and it says rates may not be excessive, inadequate, or unfairly discriminatory. You have a regulator who makes that decision for you. It's called the insurance commissioner. And 20 years ago, more than 20 years ago, I sat in this committee, not in this room, but in another place, and dealt with this exact issue. One of your predecessors had this very bill in, and it happened to be a rear-end accident on the Baltimore Beltway, making the same arguments. It's difficult, Mr. Chairman, I acknowledge, to argue that a person who suffers a not-at-fault accident should be in some way responsible for the insurance cost of that. But being a data-driven industry, we can only look at losses that are paid, and we didn't know, I don't believe even the witness who presented the bill, the fellow that had the accident, probably knows how much was paid on his behalf. But if this bill were in effect today, he wouldn't have suffered a premium increase, but all of the other people in that company would have. And that is really the fundamental reason. And finally, I would say to those who believe we should follow Virginia or one of the other 15 states, I would point out that 35 states do not have such a prohibition. And I don't think we should do so here in Maryland either. Thank you.
And again, so now what we're saying is insurance is a risky game and there are losses, right?
That is correct.
That's exactly what insurance is. I just don't, I'm so confused that you're describing the very nature of your industry and saying, yeah, and that's why it doesn't work, because the nature of my industry is that we don't want to lose, and if you foolishly hire us and then lose, we've got to punish you, even though the whole point of having insurance was to be made whole. And I say this on this. I remember back when I was younger, buying a car. You know what the first thing you did before you bought the new car? You called your insurance company, because you had to factor in what your payments were going to be, because you had to be able to afford that car in the insurance. And it just seems like such a tragedy that through no fault of my own, I may not be able to afford a car by this logic of just don't get in trouble then. Go ahead, sir. If
I may, Mr. Chairman, I respectfully disagree with your premise. An increase in premium is not punishment. That would be prohibited under Maryland law. That would be unfairly discriminatory behavior. Sure. It is intended, and you have a whole hundreds of people up in Baltimore whose job it is to make sure that insurance rates are fair.
Okay, so I want to make sure you said that. I want to make sure you're saying that if I get in an accident like that young man did and they double my insurance, that it's not punishment. I didn't say it was discriminatory. I didn't say you did because I was black. I didn't say you did because I was a dude. I'm asking you, are you saying that's not punishment?
Yes, I'm saying it's not punishment. What I'm saying is it is an appropriate, effective, accurate measurement of risk. That's what insurance premiums are. They measure the risks that they're going to be asked to pay for. You see, insurance is the only product, Mr. Chairman, that you don't know the price of when you buy it. You only know when the claim comes in.
Sure thing.
So they have to estimate it as accurately as they can.
And so I become more risky because somebody hit me. I become more risky. And it's hard to not take it personal that my rates went up versus the California thing and everybody in this region's rates go up, or our rates go up because we have horrible drivers up there where some of y'all live, and we have more accidents, i.e. more collisions, or we have expensive cars. All that stuff, everybody here can stomach why our rates are up. But then to tell me that an individual is not being punished when their rates double because someone hit them.
Again, respectfully, Mr. Chairman, I recommend that you look at the language of the existing statute. It applies to 2 or fewer claims. You get a free pass on your first not
It's
at
not a
fault.
free pass when somebody hit me.
Well, what
That's
I'm-
insane to say it's a free pass. Somehow I got lucky.
Okay,
Somebody
then,
hit me and then somebody hits me twice.
all right, I'll withdraw the free pass, but I'll say you won't get charged for it. That's what the statute says.
I agree. And all we're saying
And you
is.
won't get charged for it at the second no
Right.
fault.
And what we're
either.
saying is, again, and if you have bad luck, that maybe some people here may agree, then you shouldn't get charged for it, period. But again, clearly, we agree to disagree on this because I know we have other questions. Delegate Charkoudian.
Thank you, Mr. Chair. Is this functioning? I can never tell. Okay, there we go. Yeah. Thank you. I just want to clarify, because I feel like there's a couple of things. We have these conversations every time we have an insurance, sort of the similar conversation. And I think one of the things that you've said to us multiple times is, what is in place is not discriminatory or unfair because there is a body in Baltimore that makes sure our rates are not discriminatory and unfair. Is that essentially what you're saying?
Essentially correct.
Would you agree, though, that that body makes those decisions based on the rules that we write?
Oh, of course. The
Okay.
statutes that you pass, yes.
So to come here and tell the people who are writing the rules and are saying, we think this is unfair, so we're considering changing those rules, and you're saying to us, don't change the rules, just count on these folks over here who are going to decide if it's fair or not. We're going to decide if it's fair. We're going to tell them, and then they're going to take a look at the proposals that you make, and they'll decide in the context of the rules that we wrote whether your proposals to them are
Of
fair.
course you have the ability to
Okay.
change the rules, Delegate Charkoudian. but-
I feel like when you say to us, this is fair because they said it was fair because we haven't changed the rules yet.
You could hold that opinion, and I'll agree to disagree
Okay.
with you.
Okay. Because they said, and they were able to allow race to be used as a factor until we said you can't use race as a factor. Right? So they could use any factor until we say it can't be used. So I'll drop that piece of it. I have a second question. Thank you. Are people in Maryland required to purchase auto insurance in order to have a car in the state?
Yes, they are.
Okay. So would you say that maybe makes auto insurance regulation a little bit different than other markets that we might consider in this?
Different from states that don't require it. As far as I know, most, if
Different
not
from
all,
other
do.
business regulation that we might engage in?
I'm sorry?
Different from other business regulation that we might engage in?
I suppose so.
Like, does access to economic opportunity, is it often tied to having an automobile?
Okay, I'll concede that point.
So are there sometimes maybe economic justice issues in terms of access to an automobile and therefore like the path through auto insurance?
I am not qualified, nor will I attempt to speak to the subject of economic justice.
Okay, so the last thing on economic justice is this. I think that when you say risk of loss, what you mean is not actually, and we've had this conversation before, you don't mean was I a bad driver or was I unlucky? What you mean is, did I need to use my insurance because I don't have enough money to pay for the tree that fell on my car by myself?
I have no
'Cause if a
idea.
tree-
I have no idea if you can afford it or not.
If a tree falls on my car and I can pay it myself, that is, I have enough income, that is, I'm wealthier, then I don't file a claim, and so my insurance rates stay low. But if a tree falls on my car and I can't afford to pay for that myself, so I have to file a claim for the thing that I've been paying for the last 25 years, then my insurance rates are going to go up. So by definition, the fact that I have less access to income means that I'm more likely to use my insurance, and my insurance is more likely to go up. And so having less access to income means I'm going to have a higher insurance rate.
Actually, you were correct right up until the end, and that's where your argument falls apart. If you look at the statute today, that tree falls on your car, the first not-at-fault accident, you're not charged for it. The second not-at-fault accident, so a second tree falls on your car, you're not going to be.
Okay, then someone rear ends me, I still don't have enough money to pay for that myself.
And there comes a point where you have a number of, and this was the debate that we went through 20 years ago over this.
Okay, well, now we're having it again.
Okay, and
Thank you, Mr. Chair.
and I appreciate your opinion, but we come back to Delegate Harrison's point at the beginning. She's right no matter what. If you make this change, some people are going to pay more, a lot of people are going to pay more, maybe a little bit, they're going to pay more, a few people are going to pay less.
Carl?
Question, actually. I'm just curious, if someone hits my car and their insurance pays for the damages, do my insurance increase or it stays the same?
It doesn't impact you one way or the other. It's only if you made a claim that you got paid.
Okay, thank you.
Mr. Chairman, I haven't had the chance to speak yet.
You'll get your views from it, Bob? See him getting lined up for this. Why are you? I thought you were going to vote for a minute, but nope, that's fine. So, Steve, you sure? You want to wait and get Bob? You want to wait and get you? Go ahead, Bob.
Thank you very much, Mr. Chairman. I just want to make a couple points. You know, Maryland law is very clear right now in 11205 of the insurance article, 11306 of the insurance article, which says that you can't have a rate which is unfairly excessive or unfairly discriminatory. Rates have to be approved by the insurance commissioner. They have to be actuarially sound. So this isn't an instance, I mean, you just can't arbitrarily set a standard for your rates. Your rates are subject to review by the Maryland Insurance Administration. And they're going to look at that rate, and if you don't have an actuarial basis for that rate, they're not going to approve it. So when you look at this, you don't say, well, okay, so it's 3 not at fault accidents within a 3-year period. Okay? And if you don't have a statistical actuarial basis for saying that that is, you know, something that occurs with some insureds but not with others, and that justifies a rate increase, then it's not going to be approved by the Maryland Insurance Administration. And that's the system we have in place. They are the ones that judge. And if it's somebody doesn't think that they make a complaint to the Insurance Administration to say that, you know, this was wrong, discriminatory, it's just discriminatory based on the nature of the event, not based on race, religion, or anything else. It's based on who, you know, the ratepayers and who it may affect. Then they can file a complaint with the Insurance Administration. If the Insurance Administration says, no, we've reviewed, you know, these, we know statistically and actuarially that if you have 3 of these claims within a 3-year period, then that, you know, that's justifies an increase. And that's how the system works. And I'm not aware of if people have made complaints to the MIA that have been negatively impacted by this. I don't know how often it occurs. But that's how insurance rates are set in the state of Maryland, and they're subject to a review by the MIA. It's not just something the insurance company says, okay, here's the rate, take it or leave it. Your rates have to be approved by the MIA. Thank you.
Thank you. Yeah.
Thank you, everybody. My name is Gina Rotuno, and I am the Regional Vice President on behalf of the National Association of Mutual Insurance Companies. NAMIC is the largest property and casualty insurance trade association in the country with over 1,300 member companies. NAMIC supports regional and local mutual insurance companies, as well as some of the country's largest national insurers. NAMIC members account for 61% of homeowners, 48% of automobile, and 25% of business insurance members. It is our stance that HB 148 could lead to unintended consequences that undermine the principles of risk-based pricing that are essential to the insurance industry. First, individuals who have been involved in multiple crashes, regardless of fault, statistically pose a higher risk of future accidents. Insurers rely on this data to set appropriate premiums that reflect the higher likelihood of future claims. If insurers are unable to adjust premiums after claims, it could compromise their ability to cover the increased cost of payouts, potentially leading to higher overall premiums for all policyholders in order to compensate. Second, even if a driver is not at fault, insurance carriers may still be required to cover costs for injuries or vehicle damage if the at-fault driver is uninsured or underinsured. Finally, even a not-at-fault claim could result in the loss of a claims-free discount, further impacting the financial stability of insurance carriers. By eliminating insurance companies' ability to adjust premiums based on claims history, this bill could disrupt the fairness and financial sustainability of the insurance market. For these reasons, NAMIC opposes this legislation and requests an unfavorable report. Thank you.
I think we have Steve.
Thank you, Mr. Chair. Just to clarify again, I have insurance for a reason. I think, is there anybody up there that if you got this same claim this young man had, okay, would you be okay with it? Out of the four, is everybody okay that he got rear-ended, he reported it, and you got charged? Are you okay with your rates doubling?
Of course I wouldn't be okay.
Okay, yeah, go ahead. Who's next?
But I recognize.
No, but I don't know. I just want to know if you're okay with it. You're not. So Bob, are you okay with it?
Of course, like anyone else, I would be surprised at the rate increase, and that would make me go out and shop my insurance around.
Okay. Well, my point is that, I mean, there's nobody, probably not very many people in this room that would like that. So help us help you and help us help this out, because this is a problem. And I mean, I rely on insurance. I pay good money for my insurance. And when I report an accident, because you know what, I'm busy, I work. And I got to go through my insurance agent because I've been hit, because now there's maybe a question somewhere down the line and you're going to find somebody balked. I'm being penalized, as the chairman was saying. And I want to know if it is a statute, Bryson, I want to know how we get through that and how we address that, because this is grossly unfair to somebody who has a clean record. I've done nothing wrong, and I'm being held harmful. I'm being harmed, whether we like it or not. And I don't think it's fair. I think that's why we pay it, and it should be absorbed. If you're gonna contest that with that other insurance company, get it off the insurance company, the guy that hit it. Let them pay for this cost. Wouldn't you agree?
I'll respond this way if I may.
You may.
I normally don't name legislators' names, but I'm going to do it now. I don't think he'd mind. It was Eric Bromwell. Some of you know him. He was here 20 years ago. He had a situation very similar to the one that was presented to you today. A constituent of him got rear-ended on the Beltway, and he thought it was unfair. I understand that. Many of us who have been in that situation feel that it would be unfair if we were charged for that. And for that reason, we passed a law that's on the books today. You don't get hit, you don't get penalized, if you will, for that first not-at-fault accident. You know, one thing we haven't talked about here, and I don't want to unduly delay this, I see the chairman looking at me, is what is the definition of fault? That is a very difficult concept for some to grasp. Your predecessors, Delegate Charkoudian is right, you have the privilege of changing their decision if you wish. We are here to defend their decision. Is it perfect? No. Is it fair? We believe that it is. You have to have 2 not-at-fault accidents, actually 3 not-at-fault accidents within a 3-year period before something bad happens.
The assumption
That's
is
fair.
that this gentleman's had 2 or 3 non-fault accidents.
I'm not going to speak to his example, and I feel for him.
Okay, my last question was the one, how can we fix this? Is there some legislation that would be acceptable? We can sit down and say any non-fault accident, because that should just hold me back because I'm unlucky now. I just don't think it's right for the payer, the insurance person, the person's paying the premium. It's not right for them. It's certainly right for the insurance company because they're getting their money no matter what. But it's the person that hit you's fault. You should be able to recoup those dollars from the person that hit you. Any penalty should go to that thing because they're the one that instigated the problem.
Well, respectfully, Delegate Ahrens, I'm happy to have a longer discussion with you, and I'd want to have the insurance regulator in as part of that discussion.
I just think there should be a way, but I appreciate your
position.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. So, I mean, I've been in office for 11 years, and these insurance subjects can be some of the most heady and difficult subjects. And I think ultimately, the conclusion I come to is that the committee often struggles mightily with the conversation about actuarial tables, statistic analysis that relates to rate setting. And I know that because our legislature passed the Family Medical Leave Act, and one of the difficulties is how do you predict future use of this insurance product, i.e., how are we going to collect enough money to pay it out? And so even our legislature passes legislation where, you know, workers' compensation insurance, what's experience rating? It's a guess, it's a predictor, it's sort of, but it's also based on what you're using it, how often you're using it. So you understand our committee has this difficulty. I would assume that from your perspective, almost all of these insurance bills, whether it's territory, whether it's different analysis on any different metrics, it's all about this actuarial analysis. It's about how you set rates. So forget the topic of subject of interest, and I'll ask my question about this bill, but isn't that the struggle that you have as industry, helping us understand that at the end of the day, this is a bell curve, it's statistical analysis, it's predicting so we can actually offer insurance in our state, right? I mean, that's sort of my first question, which should be a, don't you agree, but.
Gina, you want to take that one? Since you're
Maybe
new.
it wasn't.
We have a new person here, that's why we.
It should be.
I completely understand, and yes, I do.
Right. So, I mean, so on this bill, and I'm missing, is there something so on this bill, where I'm headed is, and, you know, we all bring our life experiences, and this one's relatively personal. I mean, I haven't had a moving violation since 1997. I haven't had a speeding violation since at least that point in time. My wife and I were coming back from Louisville, brand new Toyota SUV, and we were coming into Easton on New Year's Eve, all right? It was raining that night, and I will tell you that a car was traveling on the wrong side of the road as we were doing about 65 miles an hour. Now, if you ask Chris Adams on 100 examples of that over his lifetime, how often he would do what I ended up doing, and frankly, they were doing probably 50, 60 miles going the wrong way, how many times would I have been able to achieve the task of avoiding a head-on collision on Route 50, right? Well, my wife, I'll answer how my wife answered it. We pulled off at the Royal Farm store, and I let my blood pressure settle. I got some gas, and you know what my wife said? She said, Chris, every time that would ever happen, you would avoid that collision because of how you drive, all right? And my wife's been with me to California by car, Nova Scotia, Florida, you know, everywhere. We drive a lot. And what I'm saying to the industry is that you can predict me. I mean, you can statistically line up with people like me based on my history, which goes beyond just this issue, so much to say that even if I had that accident, that first time I'm being told I get a pass, but in my case, I believe that not one time would I have been able to miss getting a head-on collision. And this is where I think the committee, honestly, on a bill like this, just bring it back to the subject at hand. All you're trying to do is statistically analyze your risk so you can make a product viable. I want to say my last thing. Government in California, I think, creates, in some cases, their own problems by their action or inaction. In Maryland, the more that we twist and squeeze and constrict and make more difficult your ability to do business, you take away the citizens' right to have insurance to begin with, which I believe we are relatively fortunate as a country, right, in our society to be able to have insurance. It's not a guarantee that we're going to have insurance. And frankly, where states and governments start providing insurance, is it better? Is unemployment insurance better because it's being handled the way it is? Workers' comp. I mean, so you're here defending not only just your industry on this bill. For my 11 years, I've watched industry come in and politely try to remind the legislature that there are things that you can do to break the insurance system. And it becomes frustrating at some level to see it happen. And so I'll just leave with this question, which is, when you see a bill like this, do you think the committee captures and understands that this is just math and statistics that help you help us buy insurance, period?
Thank you, Mr. Chairman. So just for some data for us, because I've been looking up all this while you've been talking, and I'm looking at some comparisons of places and insurance companies that have no fault, a policy that we're asking for, and comparing it to regular insurance. And actually, consistently, any place that offers that, their rates are higher. Kind of, I guess, the idea that Delegate Harrison says you're spreading it across something else, whether it's personal injury, property, or some other place. Could you provide us, for those of you that operate in D.C. and Virginia, where they have that option, this is one case where they took a hypothetical person, 35 years old, drove a 2022 Toyota Camry LE, had one accident that resulted in $10,000 worth of property damages, no injuries, and they gave me rate comparisons. Could you do something like that so I could see what it might cost for comparing DC, Virginia, and what we would be paying, so that we can start talking numbers versus all the hypothetical?
I can do that, Delegate Queen, if you'll allow me to come to your office and I can write down specifically what you just said so I convey the correct information.
Sure. Okay.
And I'll do my best to answer your question that way.
Yeah, so we can see what those rates would be.
Delegate Queen, just to point out, in Maryland, we have over 100 writers of auto insurance. In DC, there are only 20 auto insurers in that state. So there's a little bit limited marketplace. So you don't have that wide range of market for the carriers that you would have in Virginia or in Maryland.
Well, you can give me just their largest ones. I can tell you some names of what I'm saying.
I think we can figure that out, the top carriers.
Okay. Thank you. Can we do that? Thank you. Others?
I'll come see you.
All right, thank you. That'll be good. Thank you.
Vice Chair, so real quickly, just being out of state doesn't negatively affect this? I mean, one of the cases we're talking about, driver was hit in Illinois. So just to clarify, and I'm sorry if it was already asked and answered, but because he was out of state?
That's a good question, Delegate Howard. I don't believe it does. I can't be certain. I will ask.
Because I'm mystified as to why you can get 3 no at faults in a 3-year period. This happened out of state, and according to him, this was a one-time, and no fault, and his rates got raised. So I'm mystified, but I'm just trying to clarify
I assume his carrier paid the claim, and it doesn't matter where the accident occurred. If your carrier pays the claim, that's the subject of their underwriting action. So it could be Illinois, it could be anywhere.
Okay. Thank you.
If I could, Delegate Howard, let me just say that.
All right, seeing no further questions, I believe that is all witnesses for this bill. Next, we will move to House 51.
Mr. Chair, if I could bring up my panel, it is Rafael Lorente, Dean Lorente, Jonathan Schlois, Steve Waldman, and Sarah Walton. And Mr. Chairman, I do have one virtual witness as well, Joe Murkison. I'm sorry, I'm having trouble hearing you.
Yep, Delegate, I see, it looks like there's more people up there to testify than are signed up. So we'll go through it, you go through, but if they're not signed up, they're not going to testify. So just go ahead through, and then before you begin your testimony, if you could just let us know your name. Maybe I'm off, but we'll go from there, okay?
Thank you, Mr. Chair. May I begin?
Yeah, go ahead.
Okay, thank you. So good afternoon, Chair Crosby and esteemed colleagues. For the record, I'm Delegate Mary Lehman. I'm pleased to be before you to present House Bill 51, which requires a 120-day notice prior to local news organization sales. The purpose of the legislation is to keep local news organizations locally owned. This bill is modeled after Illinois legislation adopted last year and includes a notice period before local news organizations can be sold to out-of-state buyers. The bill does the following. It requires a mandatory written notice be provided 120 days before the sale of local news organizations to the following stakeholders: the organization's employees and their affected representatives, local government, and Maryland-based nonprofits in the business of buying local news organizations. The bill applies to local news organizations that are print only, that are digital only, or hybrid digital and print. It also details the percentage of local news content that it must include, and that is to avoid what is called ghost news organizations that actually have no local journalists and no local coverage. So the problem this bill is trying to address is the loss of newspapers nationwide. Since 2005, nearly 3,000 newspapers have shut down. Northwestern University's annual State of Local News report in 2023 found more than half the counties in the United States have either one or no local news outlet. Another concerning finding is the disparity around newer digital-only or ethnic media organizations locate, which is more affluent urban areas. So that means when lower-income or rural communities lose their local newspaper, they are much less likely to get a replacement one. A co-author of the study said this has resulted in our country becoming one of journalism haves and have-nots. In Maryland, we have no counties without a local news source and 7 counties with just one. However, a University of Maryland survey found 60% of those outlets have staffs of 5 people or fewer, and 40% could be facing closure within 5 years without an infusion of revenue. So why does this matter? It matters because local news is an important source of information about local government, about public safety, neighborhood issues, schools, and much more. Local news promotes public awareness and it increases civic engagement, which is mutually beneficial to residents and to all of us here as elected officials who need to work together to address community concerns and problems. Without local news, it is much more difficult to maintain these connections. In closing, I just want to say Maryland's local news organizations need help, and HB 51 could stabilize and preserve a critical resource for our communities. I urge a favorable report. Thank you. And could I ask Dean Lorente to go next?
Okay. Thank you, Chair and members of the committee and Delegate Lehman for inviting me here today. My name is Rafael Lorente, and I'm the Dean of the Philip Merrill College of Journalism at the University of Maryland. Before joining the college, I spent 20 years as a reporter covering every level of government, from small towns and large cities, the Florida legislature, Congress, the White House, federal agencies. Merrill College is one of the country's best journalism programs, and it sits in one of America's finest public universities. We train the next generation of journalists and researchers, as well as provide writing and critical thinking skills for students who enter law, public service, and other fields. Many of you know us because our student reporters in Capitol News Service have covered press conferences, legislative hearings, and more here in Annapolis and Washington and around the state for 35 years. We also run the Povich Center for Sports Journalism, the Howard Center for Investigative Journalism, and the Local News Network. Last year, as Delegate Lehman pointed out, the Local News Network published a first-of-its-kind news ecosystem study of Maryland. Our goal was to find out what kind of access Marylanders have to information. We weren't interested in national coverage, but in local coverage about millage rates, garage sales, and high school sports. We gathered information on traditional news outlets, but also on Facebook pages, neighborhood email listservs, and other methods. I've included a link to the study at the end of my written testimony. It's not a pretty picture. Several counties in the state, especially in western and eastern Maryland, have little coverage of town hall meetings, school boards, and other institutions. Large counties like Prince George's and Montgomery do not have a single outlet devoted to covering the counties as a place, leaving county executives, county councils, courthouses, and other institutions without coverage. Maryland is not unique. Around the country, local news outlets are disappearing at alarming rates. The consequences are not good for those communities and the people who serve them, the police, the firefighters, doctors, nurses, and others. The disappearance of local news leads to lower civic engagement, less volunteering, and more polarization. Mis and disinformation often fill the void. HB 51 would not solve all of those problems, but it could provide some relief. You see, before many local outlets close, they are often purchased by hedge funds or private equity firms that are not interested in providing maritime conditions around Annapolis or crop information in Millsboro or traffic patterns in DC or Baltimore or even ski conditions in Deep Creek. They buy these outlets and slowly strip them for parts, taking every penny of their value out of our communities. Giving advance notice might allow time for local investors to buy a news outlet before it suffers that fate, or it might allow a nonprofit to form. In every community that a news outlet is saved and stays independent, you will have a better chance at informed, safer, and more involved constituents. You may even have friendlier neighbors, because while we often disagree about national tax policy and foreign affairs, most of us want paved roads, good schools, and safe streets. Our founders knew that and made freedom of the press a bedrock right. We are the lucky descendants of their wisdom. Thank you. I urge you to support this bill.
Thank you, Chair and Vice Chair. My name is John Schlois. I am the president of the News Guild Communications Workers of America. We are the largest union of journalists in North America. I myself am a former journalist. I write, or I'm here in support of HB 51. I thank Delegate Lehman for introducing this legislation. It would give us time, critical time in this moment. We represent folks at the Baltimore Sun, at the Capitol here, and at the Washington Post, among many other publications. And one of the things we struggle with is time. As journalists, myself experiencing this directly, we are constantly faced with changing ownership that has different ideas, new ideas, different ideas, and then they walk out the door. Then we have new owners come in, and then they walk out the door. And a lot of times, they are controlled by hedge funds and private equity, and they have no interest in providing news to our communities. This bill would give us a 120-day period so that we could slow things down and try to find alternative owners, so we're not just gobbled up by the next private equity fund that's going to destroy a great institution in our communities. The constantly changing ownership has been a major distraction for many journalists who just want to do our jobs, reporting the news and seeking the truth. As Delegate Lehman said, the financialization and consolidation of the news is destroying the entire industry. Since 2005, we've lost a third of America's newspapers, but more specifically, we've lost more than 43,000 newspaper journalist jobs, which is undermining our democracy directly. It's critical now that we stand in support local journalists and local newsrooms by slowing down the consolidation of the news industry. One of the things that we engaged in when the Baltimore Sun was being gobbled up by Alden Global Capital was to try and launch a campaign, Save Our Sun. That led to Stuart Bainum coming forward and trying to purchase the Baltimore Sun. Alden Global Capital kept raising the price. He ultimately failed and set up the Baltimore Banner. We need more time so that we can do more of these efforts to find more local buyers of local newsrooms so that they stay owned here in Maryland. Thank you. And I urge a favorable report from the committee.
No questions? Next, please.
Hi there. Thank you, Chair, Vice Chair, and members of the committee, and Delegate Lehman for the invitation to speak. My name is Sarah Walton. I'm the Chief Philanthropy Officer at the Baltimore Banner. As a nonprofit news organization, the Baltimore Banner is driven by our mission to inform communities across the state of Maryland with balanced, trusted, and compelling local reporting. As I can personally attest, as the Banner's Chief Philanthropy Officer, we and other innovative newsrooms across the country are proving that the nonprofit model can foster independent, financially sustainable news operations. We and other local nonprofit news operations are helping to address the holes in our information ecosystem caused by the loss of so many legacy media outlets over the past 2 decades. An alarming trend with well-established negative consequences, such as declining civic engagement and increasing local government corruption. At the Banner, we embrace the presence of other local news organizations in our orbit. A bit of friendly competition drives us to be the best we can be, enables media organizations to help hold each other accountable, and contributes to a healthier news ecosystem overall that benefits all of our communities. According to the first ever Maryland local news ecosystem study that Dean Laurenti just referenced, from last year, 40% of news organizations in our state are skeptical they can survive another 2 years without revenue growth. When a news organization faces the prospect of a sale or closure, whether due to financial distress or other reasons, the employees of that organization and the affected community should be given adequate notice to weigh the implications. Communities should have the opportunity to prepare an acquisition plan, whether the potential acquirer is an existing nonprofit news organization, or if employees or other prospective local owners are interested in preparing an offer. House Bill 51 would strengthen Maryland's news ecosystem by preventing local news entities from disappearing and keeping ownership in the hands of communities they serve. Thank you.
Thank you, Chair Wilson and Delegate Ullman. My name is Steve Waldman. I'm the chair of the Rebuild Local News Coalition, which is an alliance of 40 national and state associations and journalism organizations across the country, representing more than 3,000 local newsrooms and thousands of reporters, including many in Maryland. Half of the daily newspaper circulation in America is now owned by a hedge fund or a private equity firm. Half. That is one of the causes of the crisis that we're in. And you in Maryland have seen this up close, that when newspapers are bought by big chains that are controlled by out-of-state financial institutions, they tend to slash the number of reporters more. A recent national study by Professor Michael Ewens found that the number of, after an acquisition of this sort, the number of reporters fell by 40%. The number of articles about local government fell from 5,700 down to 2,500. By contrast, family-owned newspapers and locally owned newspapers were more likely to maintain the levels of reporting and of coverage. So any strategy to try to help save and rebuild local news should have a goal of, whenever possible, keeping local news in local hands. This proposal is a modest, common sense proposal. It doesn't prohibit the sale to a hedge fund. It doesn't require a right of first refusal. All it does is give some time, 120 days, so that a community can organize a chance to keep the local news in local hand. And by community, I mean it can be local business people, it can be foundations, unions, employees, nonprofit organizations, public radio stations, anyone who cares about the information health of their community. No, by itself, this will not solve everything. A hedge fund could still outbid, but this would at least ensure that it doesn't happen under the cloak of darkness, and it gives the community a fighting chance.
Thank you very much. Lastly, we have Mr. Joe Murchison. I believe, sorry about that. We have a gentleman on Zoom. Are you ready to testify, sir?
Yes, I'm Joe Murchison from Laurel in Prince George's County.
Oh, you can go ahead and start. Yes, sir, please.
In my 24 years as a Maryland journalist, I directly experienced the disheartening results of local newspapers being acquired by out-of-state corporations. I was hired in 1983 as an editor at the Columbia Flyer, which at that time was recognized as one of the top weekly newspapers in the nation. And in 1985, the chain that owned the Flyer, Patuxent Publishing, moved me to the Laurel Leader, another proud paper, where I served as editor for 17 years. My early years at the Leader were really good, with excellent support from the executives at the chain's Columbia headquarters. But then came a series of transfers of ownership, first to the California-based Times Mirror Corporation in 1997, and then to the Chicago Tribune Corporation in 2000. Naturally, the executives in Los Angeles and Chicago didn't care about the communities we covered. They were far away. They were focused on maximizing their profits from our holdings, and that meant doing what was most in their control, cutting expenses. As a result, our staffs were shrunk, the size of the papers dwindled, and concerns about editorial quality and serving the communities went out the window. We went into a downward death spiral. Tremendously dispirited, I left the sinking ship in 2017. By 2023, after more transfers to other out-of-state owners, the Columbia Flyer and the Laurel Leader were shut down. The Leader was 125 years old, the Flyer 54 years old. I applaud HB 51 as a tool to slow this nationalizing of media ownership and the death spiral of local media that it brings about. Thank you.
Thank you very much, sir. I have one question. Delegate Fisher.
Yeah, actually. Thank you, Mr. Chairman. This is an interesting issue. Thank you, Delegate Lehman, for bringing this up. I'm just curious, I mean, in my county, we had a couple of papers and now they're gone. We have a one-person paper now, which I'm sure is not unusual. I mean, I'm going to state the obvious. To what extent is it just technology and the fact that readers can just go online and become maybe even their own journalist if they want to?
No, that's a valid question. I would like the dean and others maybe to chime in, but I would just say there is a definition of what, what local news means and to whom this bill would apply if this does pass and become law, where that 120 days kicks in. And it does cover digital-only scenarios, print-only, and then hybrid situations, because there are more in different, media products all the time. But if the dean or anyone else would like to comment on that trend or what that means for the loss of jobs and that kind of thing.
Delegate, you're absolutely correct. It's technology, it's the business model. The ability to shop for your classified somewhere else than your newspaper did a lot of damage to the newspaper that I worked for. Our challenge as whether it's journalists or communities or business people is to find a business model that works if we want a society that's informed and makes decisions based on good information. I haven't seen the answer. I've seen a lot of really good attempts, including the Baltimore Banner. What this bill might do is give us a little time, and I think that's what's probably needed.
To what extent are these large hedge funds and Jeff Bezos, for example, with the Washington Post and perhaps others, past and present, responsible for the incredible one-dimensional thinking at the newspapers? I mean, it's a fair question. I mean, the Washington Post, it's long since lost critical thinking skills as a paper. Was that caused by the owner, or was that caused by the writers? Well, because here's why I ask, right? Maybe the exodus of readers is because of that, and clearly that's not the only contributor, but it is one of them for sure. And I'm just, believe me, I'm on the side of wanting these papers back in my county. This is the great struggle, right? I'm like the quintessential conservative that grew up in a critical thinking liberal family, and I'm a critical thinker. I want to hear the other side, but I don't see it.
So when I was working as a journalist at the Los Angeles Times, which was also owned for a time by the Times Mirror Company and was, not caring about the other publications, including the Baltimore Sun at the time when it owned it, not giving it enough care. My job was to try and think of innovative ways to tell stories. I'm one of the few union presidents that knows how to write computer code, for instance, and come up with new ways to tell stories. We were trying to reach new audiences, right? I think innovation is a key component of every successful business. And I frankly, as a person who represents the working journalists at a lot of newsrooms, I don't see a lot of the leadership thinking that critically. I think some really good models are coming out. I really praise the Baltimore Banner for what they're doing. The New York Times has been able to modify its revenue streams to create like cooking apps, to create games. So there are places where those innovative ideas are happening on that front. I think that's one core part of it. I think, as we said before, the financialization of the industry is a big component of the loss of local news, because you have hedge funds gobbling up, getting rid of the real estate, cutting a bunch of staff positions, cutting all, basic things like hot water in the bathrooms or reporters' notebooks. And then the third and final thing I think is a big critical component. When I started, my first job was at the Arkansas Democrat-Gazette, and for every dollar that we earned in revenue, we would say 90 cents came from print advertising, right? As we've switched to digital, that's meant more and more readers have moved online, but I think also a big component of that has been the gobbling up, almost a duopoly of digital advertising by the two main players of Google and Facebook. But this bill, HB 51, really works to address that financialization issue, which is critical. We've seen the destruction of great publications like the Denver Post, the St. Paul Pioneer Press, the Baltimore Sun. I just talked with one of our workers at the Sun this morning, and since last March, we have lost 19 journalists in that newsroom, and it's just unbelievable. And the folks who are there are trying their darndest to seek truth and report it. I mean, that's our job, right? Our job is to think critically and to find that truth. And you can only do that in a community way, and more journalists is the solution that I'd argue.
Yeah, if I could just add to that. On your first question, it's true that every local news outlet is hit by that big systemic problem of the ad revenue leaving. It's mostly the ads leaving more than it is the readers leading. Yeah. But we have seen that institutions that are locally grounded actually do better than the ones that are owned out of state and that are owned by financials. So even given those same big meta forces, some do better than others. Unfortunately, I can't speak to whether this is the case in the examples you said, but one of the sad things happens is a downward spiral where a out-of-state firm cuts the newsroom and the quality goes down. Mm-hmm. Because you have, instead of having, one reporter covering these schools in town, you now have one reporter who covers the schools and the healthcare system and the criminal justice system. Well, of course, it's going to be more superficial. So you have this downward spiral in quality as well.
Just last question. Thank you, Mr. Chairman. And that is Substack. Do any of your papers allow you to do a Substack and also have the article printed in the, if you will, the paper?
Sure. So Substack is a form of technology. I mean, individual writers are using Substack to, build subscription following. Some publications, for instance, we have a strike publication in Long Beach, California that used it as software to publish their website. So yeah, it can be used, but typically, especially for my members, they're full-time working journalists in most newsrooms. We do represent some freelance journalists as well.
Thank you. Thanks.
Thank you, Mr. Chair, and thank you, Delegate, for bringing this bill. As a kid who grew up with the Baltimore Sun, I watched it, used to read it every Sunday with my grandfather, and I've seen what happened to it over time. And Baltimore Banner is doing a great job, in my opinion, of trying to replace what we needed there. But my question is more so to some of the specifics of the bill in regards to timing. As a person as an attorney who's worked in the private equity space and helped people sell their businesses to private equity, and have helped private equity firms actually acquire businesses, wanted to get a better idea of why the 120 days. Do you think it's a realistic time frame to put together a counteroffer? Would it be more amenable to do something longer? Just want to get a better idea of why you chose 120. Maybe you all understand the market better than me. I'm just worried that, is that a sufficient amount of time? And then also, kind of a companion to that question is, if you have a board or you have people who have the responsibility of getting the best offer, at a certain point, the money's just always going to kind of win. So how do you compete with that part?
Great question, Delegate Ampry. I'd like to take a first shot at it and open to my panel weighing in as well. So the short answer on the 120 days is that was taken from the Illinois statute, and that is law. However, I have been asked that question, for example, by the Press Association, and one of the issues raised was, well, what about for a very small organization that's barely getting by, operating, just at those margins, and what if this person asks you, what if 120 days is too long, and in the meantime, that organization goes out of business? And my response to that was, I'm open to that conversation, but look at it the other way. If it's too narrow a window, let's say we lowered it to 90 days, and I'm not saying that's out of the question, but if we make it too low, I believe it's a balancing act where if, say, there's a group of employees or a business group, wherever it is, trying to put together financing to make a credible offer, they're going to need more time rather than less time. Is 120 days the exact right amount? I'm not sure about that, and I'm open to further discussion on it. But I do believe that is a balancing act.
I just want to get an idea of where, I assume that number came from a place of either another statute or there was like a reasonable reason, and that what you've explained makes sense.
And I welcome any of my
Yeah, and we were involved in that Illinois law, and the research on that went exactly to the balancing act that you laid out. If you make it too short, then it defeats the purpose of the bill. It's not going to be, you're not just notifying employees to prepare them for their job loss, you're trying to give a community time to organize a bid, which takes a little bit longer. So what we were told, including by people who were involved, newspaper sale brokers and foundations and people who are in the business of trying to arrange these acquisitions, was that if you did it too much, less than 120 days, then you wouldn't have enough time. If you go too far, though, you have the opposite problem of you start to make some of these you can really put some of the newspapers in jeopardy or make a potential deal, evaporate or something like that. So they tried to find the medium, the right balance between those two goals, and 120 seemed like the right spot.
Got it. Okay. And I guess the other part of the question is just like thinking through. Again, I love the idea of this bill. I love the concept of ensuring that we keep our news as local and as on the ground as possible. But still, I was thinking about just at the end of the day, like the for-profit space is the for-profit space in the sense that, like, you want to do this right. If you have a bid that's just so low, the board has a responsibility to take the higher bid. And is there anything you all can think of that could possibly, maybe it's not an answer you have right now, but thinking about how we can think about that as well, because that's my other worry.
But again, Delegate Ambrey, just to put a point on it, it does not preclude a sale to an out-of-state entity.
Right.
And it doesn't preclude anyone from outbidding anyone else, including local organizations.
Right.
Thank you.
Yeah, thank you.
Thank you, Mr. Chairman. First, I want to acknowledge my colleague who mentioned, and I agree, that liberals foster critical thinking. Thank you for that.
That was traditional liberal thinking, not common liberal.
You already said it. It's done. We're woke, and you like to be woke. So my question is, could a community college or something like that be a buyer of this? How have we looked at that? Because they have the infrastructure and they could possibly certainly take this on. Is that an option as part of this?
A community college or the University of Maryland College Park?
A community college. You need something in that rural area to help you guys out with your papers.
Question.
So a rural community college down in some of these places might be helpful.
So Delegate Queen, as a very large university, we have run our own news service for more than 3 decades, and it's very hard to do. To not just because of the staffing, but because students aren't there 12 months a year, because they come and they go. They don't have sources because they can't spend 5 or 6 sessions here getting to know you, so they come and they go. All across the country, and we are one of the first 3 or 4 schools to start doing this back in 1990. All across the country, there are universities, colleges, community colleges, often supported by foundations and others, trying to take up some of that slack. State houses were the first place to lose reporters. If those of you who've been here a long time, there were a lot of reporters here 30 years ago. There are not as many today. But it's a very difficult thing to actually run it. University of Georgia is trying it. There's a couple of places. But there are ways to partner to do it. And there is actually an effort underway right now at the University of Southern Mississippi partnering with community colleges and a very large foundation to try to do just that.
And to, just to convey that.
like to speak in, I guess, since you did travel over here, of course.
I'm so sorry if I wasn't on.
That's fine, sometimes I guess it's challenging.
One, Hey, good to see you. Hello, everyone. I am Rebecca Snyder. I'm the Executive Director of the Maryland-Delaware DC Press Association. Thank you for your substantive discussion on this bill. And we don't have a position, but we have worries, we have concerns. I think the previous panel really laid out that news media is struggling. There's difficulties, there is, but underlying all of that, news media is a critical force for our democracy, and it's necessary. And so the question is, how do we support that? When you think about the Illinois bill that this legislation takes inspiration from, it was a tripartite bill that bundled in supports for local media, some scholarships, some journalism funding, as well as this provision. There has been no newspaper that's been sold under that bill, so it went into effect in January. So, and there's nothing else, I believe, like it. So our concerns, and we're working with Delegate Lehman on this. I mean, everyone on the panel was our friends. You know, we represent the Banner, we represent, all the major newspapers, including the Baltimore Sun. And it is painful to see the cuts that have happened there. But when we look at the bill, that 60% of newsrooms are in that 5 to 7 journalist range. You know, yes, half of the journalists in the country perhaps are under ownership, the publications are under ownership by hedge funds because they're the largest entities. So I'm concerned about the small, struggling, 1, 2, 3 person shop. And I do worry that if I'm a newspaper owner and I tell my employees, my community, and this ambiguous and unknown to me entity that is nonprofit that buys up newsrooms, then I might bleed out in 120 days while things while everyone's saying, oh, she wants to sell, what's going to happen? Is that important? So timing, ambiguous language. I don't know of this nonprofit news organization that would buy up other newsrooms. I don't know who's checking the boxes on how that notice happens. And the stakes are high. You can't invalidate the sale, but you could stop the sale. So when the Sun, just thinking through it.
Ma'am, I just need you, that little horn means you got to wrap it up.
Yep, so there's concerns about ambiguous language, how you enforce it, who's checking the boxes on whether notice was provided and how that works. And then lastly, there are some First Amendment concerns. You're putting a regulatory burden on a industry that you're not putting on anyone else. And so that is a concern. We want to work with Delegate Lehman because I sit here every day and advocate for news media. I want us to succeed. So I just wanted to bring those concerns. Thank you.
House Bill 92. I apologize. No, the House Bill. Yeah, House Bill 92. Yes.
Good afternoon, Chair Wilson, Vice Chair Crosby, and members of the Economic Matters Committee. For the record, my name is John Dove, and I serve as the Commissioner of Occupational and Professional Licensing with the Maryland Department of Labor. Today, I am testifying in support of information on HB 92. If passed, this bill would change the current time limit required to take the examination to renew an HVAC license that has expired from 90 days to 4 years. Maryland's current statute requires an individual to retake the licensing exam if their HVAC license has expired more than 90 days for any reason. The 4-year renewal limit was determined because the industry currently operates on a 3-year code cycle, and the adoption process and use in the state of Maryland can take an additional year. An individual whose license expired less than 4 years ago has been actively working within the current code cycle, and their training is aligned with it. This practice would be more consistent with the other boards of the mechanical licensing unit, e.g. our electricians and our plumbers, as most boards allow between 2 and 4 years before re-examination is needed. The current process for mechanics to remedy a lapse in licensure consists of 2 lengthy steps. First, applicants must apply to PSI, the testing vendor, as if they were new applicants, then wait for the board's application review committee to approve their application, which can take up to a month. If they are initially approved, scheduling the exam is often delayed due to limited availability at testing sites. In the second step, after passing the exam, applicants must return to the board and apply for license renewal, thus navigating additional internal steps that may cause further delay. This prolonged process leads to frustration, leaving individuals with expired licenses and facing the risk of working without a license, which can result in fines and even imprisonment in some situations. Changing the licensing timeframe from 90 days to 4 years brings parity with the other mechanical trades, renewal processes, and would provide a person who is currently employed the flexibility needed to complete the license renewal. This approach benefits both technicians and their employers. With that, I respectfully request a favorable report by the committee on HB 92. Also online is the Executive Director for the Mechanical Boards, Chuck Marquette, who's online to help us out with any questions that I may not have details to answer. Thank you, sir.
Mr. Marquette, choosing to testify or just be here for information?
Just information.
Andrew, you just hang out?
Yep, and Mr. Chairman, Andrew Fulgeniti, Legislative Director with the department. I'm here for questions as well.
Well, see no questions. Great job, guys.
Thank you. Next one.
Right. Next bill is House Bill 78.
I've got that one also. This, again, Chair Wilson, thank you again, members of the Economic Matters Committee. Again, John Dove for the Commissioner of Occupational and Professional Licensing. I'm testifying on HB 78. It is necessary, this is a sunset extension bill. It is necessary to extend the State Commission of Real Estate Appraisers, appraisal management companies, and home inspectors in the Department of Labor to protect Maryland citizens who are licensed to provide real estate appraisal or home inspection services for their livelihood, protect prospective purchasers and sellers of real property, and protect lenders who rely on such services in related transactions, and to comply with federal law requiring that all states implement an appraisal licensing program in accordance with federal requirements. The Commission of Real Estate Appraisers, appraisal management companies, and home inspectors has been subject to prior sunset extensions since its creation in 1990 and most recently in 2023. The Commission receives approximately 110 complaints per year against its 3,700 plus licensees. Complaints are processed immediately upon receiving them and are typically closed within 120 days. Currently, there are 21 open complaints against licensees. The Commission processes approximately 1,500 total licensing applications per year. As with complaints, applications are processed immediately without delay, typically issued within 3 to 5 days. Additionally, the Commission has been proactive in addressing concerns of bias within the Maryland real estate appraiser community. All Maryland real estate appraisers are now required to complete racial bias training as part of their education before renewing their licenses. The Commission has also established a memorandum of understanding with the Maryland Commission for Civil Rights to handle complaints related to racial bias against appraisers. Furthermore, the Commission has removed the requirement for a 4-year college degree to become a certified appraiser, expanded opportunities in the field. In addition, the University of Baltimore will conduct an independent evaluation of the Commission's practices to ensure compliance with all statutory requirements and to offer recommendations for potential improvements. Also in line with me is Executive Director Todd Blackstone on virtually, just to answer any questions that I may not have the detail to answer. With that, I respectfully request a favorable report by the committee on HB 78.
Thank you, Chair. So on home inspectors, do you get complaints?
I'm not interested in, you've shared the other appraisals and rationale for that, but for home inspectors, do you get in?
We do get some.
What are the general nature of the complaints?
I'll pass that to, is Mr. Blackstone on virtually?
Mr. Blackstone, is it on there? Yes.
If we could bring him up, and that would.
This is supposed to be just a quick question. I can always do this offline. Mr. Chairman, I'll ask offline.
We can get you that.
It sounds
We can
like
get you that
there must be
information,
something wrong
Delegate.
Yeah, we're having some technical difficulties, so no worries. Seeing no other questions on this bill, moving on from House Bill 78 to House Bill 63.
Which is also a sunset extension. Again, good afternoon, Chair Wilson, Vice Chair Crosby, members of the Economic Matters Committee. Again, John Dove for the Commissioner of Occupational and Professional Licensing. I'm testifying on HB 63. This bill proposes to continue the Maryland Board of Public Accountancy, which is scheduled to terminate and be of no effect after July 1, 2025. This bill will continue the board through July 1, 2030. It is necessary to extend the Maryland Board of Public Accountancy, which is scheduled to terminate after July 1, 2025, for the safety and welfare of all Maryland citizens by ensuring that CPAs can continue to become licensed and maintain that licensure throughout the state. Also, this will allow the board to continue to make sure that CPAs are held in compliance. Maryland was the third state in the country that created the professional designation of certified public accountant. Currently, there are a total of 19,206 CPA licensees and firms in Maryland. Without the Maryland Board of Public Accountancy, those licensees will no longer be able to use the title they work so hard to earn. Maryland was the third state in the country that created the professional designation of certified public accountant. Currently, there are a total of 19,200. Yeah, okay. Okay, also, they may have to gain licensure in states which reduce the amount of revenue generated in Maryland. Licensees are processed by board staff as soon as all the requirements have been met by candidates, usually within a week, except in certain circumstances where approval or denial is required by board members. In these cases, the applications are reviewed at the next board meeting. The board receives approximately 80 complaints in a fiscal year. These complaints are typically resolved within 60 days unless a complainant or respondent requests an extension to respond to the complaint. We believe that those individuals who choose to become a CPA should have the right to legally work in Maryland, stay licensed in Maryland, and offer protection to the hardworking citizens of the state who require the use of an accountant who is held in compliance by the board. With that, I respectfully request a favorable report by the committee. I do have Chris Dorsey, our Executive Director of CPAs, on board if there are any detailed questions that we cannot answer.
Do not see any questions. Don't worry about it. Thank you guys.
Thank you very much.
Good afternoon, Mr. Chairman, Vice Chair, delegates, friends. My name is Michael Laurie. I'm the Deputy Secretary of State. I'm back with you today. We had this bill before you last year. It's substantially similar. This is House Bill 239. It's our one departmental bill. What it does is it tries to solve two problems, and we have Mike Schlein with our Charities and Legal Services Division, and Alex Ayers, who is our Assistant Attorney General, to answer questions. This bill, again, is very similar to the bill you had last year. It was not filed in the House last year. Thank you, Mr. Chairman, for taking on our departmental. All the bill really does is it solves two problems. The first one is we got an audit, and you can see in the fiscal note, we thought we were inappropriately being told to send the fees that we collect to CCU, and that doesn't do anyone any favors, because if it goes to CCU, we can't work with the charities to bring them into conformity, and no one likes to deal with CCU. So we disagreed with the auditors, but we'd like to make sure the law is crystal clear. We'll probably get another audit coming up in a year or two, so we'd like to make sure the auditors don't just believe our story, but they believe that this is the intent of the legislature to not send these fees to CCU, because, again, we use them to negotiate with the charities. There's a lot of turnover on the boards, good faith actors, and we want to just bring them in conformity with the law. We don't want to hit them over the head with additional fees and burdens. The second thing it does is it allows us to suspend these charitable organizations when they don't get back to us. When we have late fees that accrue and they're not being responsive, they're still on the list of registered charities. We want to make sure the charities that are on our list are the ones that are conforming with the law, and they're on our radar. We're more easily able to enforce actions against them, and it's in some ways a signal to the public. These are the registered charities. We know about these charities, and we're more likely to be able to hold them accountable if they're not providing those hard-earned, transferring those donations hard-earned from constituents to the intended purposes. So we can get into the details of how that enforcement mechanism works. Somewhat unique in Maryland. We work with the Office of Attorney General, and I think the system works really well. Mike Schlein is an all-star. He's been doing this for decades now, and our charitable enforcement is better than it's been probably in the last, 20 years. So happy to answer any questions. There's one minor amendment that we request. For some reason, this is not in conformity with the Senate bill. The cross-file is correct. This bill just has a vestige from last year's, which we were hoping we can just, and I think the chairman's been made aware on page 3, line 19, it mentions the imposition or collection of. That just confuses what we're trying to clarify. It's not really an imposition or collection. What we're doing is trying to work with these charities, so we just want to clean that language up. Thank you.
House Bill 119. Is anybody here to testify on behalf of that bill? Well, seeing that there's nobody here to present that bill, I guess we'll move on to the next one. This is House Bill 30. Underlying credit insurance.
Good afternoon. Chair Wilson and members of the committee, thank you for allowing me the opportunity to speak in support of House Bill 30. I'm Mary Quay, Associate Commissioner for Market Regulation and Professional Licensing at the MIA. Credit insurance is intended to make payments or pay off a loan if you qualify for benefits under the policy. And it is often sold by people who are not traditional insurance producers who can obtain a limited lines license in order to sell only credit insurance. In order to apply, the applicant must complete a course provided by the insurance company. Currently, the course must be approved by the commissioner in advance, but there are no standards for approval or disapproval. The proposed changes would eliminate the need to file for approval in advance and instead would create record retention requirements so that the MIA could request certain documentation and have standards to ensure that the companies and producer license applicants are complying with the law. This would relieve carriers of the requirement to file course materials in advance and would allow the MIA to conduct efficient regulatory review through market conduct or producer enforcement. And so we urge a favorable report. Thank you.
Well, I see no questions. Good job, ma'am.
Thank you.
Colleagues, I do believe that